The Bill of Rights, Amendment 4, states, "The right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall be issued but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." The Fourth Amendment to the United States Constitution was added as a part of the Bill of Rights on December 15, 1791, and deals with protecting people from searching of their homes and private property without properly executing search warrants. The founders believed that freedom from government intrusion into one's home was a natural right, one granted from God, and fundamental to liberty. The idea the citizens should be protected from unreasonable searches and seizures goes back far into English history. In 1604, Sir Edward Coke first identified this right. He said that, quote, "The house of every one is to him and his castle and fortress, as well for his defense against injury and violence as for his repose." During the colonial era, the King of England looked at the American colonies as simply a financial investment. Britain passed numerous revenue collection bills aimed at generating as much money from the colonists as possible. Obviously, the colonists resented this act by the king and began smuggling operations in order to circumvent the custom taxes imposed by the British Crown. In response, King George III began to use the conveniently worded writs of assistance. These were legal search warrants that were extremely broad and general in scope. British agents could obtain a writ of assistance to search any property they believed might contain contraband goods. They could actually enter someone's property or home with no notice and without any reason. Agents could interrogate anyone about their use of goods and force cooperation of any person. These types of searches and seizures became absurd to the people of the colonies. These actions by the British Crown would be one of the factors leading to the American Revolution and eventual forming of the United States Constitution. When the Fourth Amendment became part of the Constitution, it was originally only applied to the federal government. Later, it was applied to the states through the Due Process Clause of the 14th Amendment. Of course, in today's world, there are many exceptions to the Fourth Amendment. Law enforcement officers now must have a properly executed search warrant issued before a search or seizure of private property can be conducted. There are numerous court cases that led to today's interpretation of the Fourth Amendment. The first being Weeks versus the United States, which happened in 1914. Police officers in Kansas City, Missouri went to the house of Mr. Fremont Weeks and used his hidden key to enter and search his home. While there, they took papers, letters, books, and other items. They did not have a search warrant for this search. These items were used in court to find Mr. Weeks guilty of sending lottery tickets through the U.S. mail. The judgment of the district court was reversed. The evidence collected during the illegal search was a violation of the Fourth Amendment and was thus inadmissible in trial. In a criminal investigation, in order for a search to be legal, there must be probable cause. The probable cause must be used to gain a search warrant. If not, the search will be illegal and evidence collected as a result of a search can't be used in court. The Weeks decision was the birth of a new legal doctrine called the exclusionary rule. Another court case known as Vernonia School District versus Acton in 1995 was also landmark. A school district adopted a policy authorizing random drug testing of student athletes. There was a known drug problem in the school district. Student athletes were among the drug users and dealers. Along with the drug problem came serious student behavior issues. By 1989, disciplinary action had reached epic proportions, motivating the district to introduce the student-athlete drug policy. James Acton, a 7th grader, refused to take the test, and his parents refused to consent to the test. Because of this, he was not allowed to participate in football. He sued the school district for violating his rights. The drug testing policy is reasonable and does not violate the Fourth Amendment rights of the student. Students do have rights at school, but those must be balanced with the school's responsibility to provide a safe environment. Finally, one of the more well-known court cases involving the Fourth Amendment is known as the Stop and Frisk case, formerly known as Terry versus Ohio. A police officer witnessed 3 men pacing in front of a jewelry store and suspected the robbery was being planned. He approached the men and identified himself, then performed frisks and defendants Chilton and Terry and discovered illegal concealed weapons. Defendants were convicted and appealed, claiming that the frisk violated their Fourth Amendment right against unlawful searches and seizures. The Supreme Court upheld the conviction. finding that when a law enforcement officer has reasonable grounds for suspecting a criminal suspect may be armed, he may pat down the outer layer of the subject's clothing for weapons. The ruling held that the Fourth Amendment protection against unreasonable searches and seizures is not violated when a pat-down is performed, based on reasonable suspicion for the purpose of ensuring officer safety. Thank you.